Texas Penal Code 8.02, the mistake of fact defense. Let's take a look. So here's what the statute says. 8.02, mistake of fact. It is a defense to prosecution that the actor, through mistake, formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for commission of the offense. So, if you had a murder case and you thought you were shooting a squirrel off your back porch, but what really happened was you shot somebody in the bushes and killed them, this is the classic example of the mistake of fact defense. Subsection B has this sort of a carve out. Although an actor's mistake of fact may constitute a defense to the offense charged, he may nevertheless be convicted of any lesser included offense of which he would be guilty if the facts were as he believed. Let's look at a case. In Baez versus State, we have somebody who helped another person punish a child by putting them in a bathtub with really hot water. And the appellant, which is the defendant in that case, admitted to helping her stepdaughter punish RMB, which was the child, by administering a bath which scalded RMB. Her defense was that she did not know that the bath water was hot enough to cause injury, the water having been drawn by her stepdaughter before the appellant came into the bathroom to help. She thought that it was a normal bath temperature. So the jury gets to believe or disbelieve that however they want. But in this case, the court gave a generalized instruction to the jury. They just basically said, here's the law on mistake of fact. And we'll see how the court treated that here on the next slide. What the Court of Criminal Appeals said is that the trial court's refusal to give a charge that applied the law of mistake of fact to the very facts of the case over the appellant's objection and in the face of a properly requested charge was reversible error, and the judgment is reversed and the cause is remanded. That means that the defendant got a new trial so that a jury could see not only did this mistake of fact defense potentially apply, but they had to apply it to the specific facts which the defendant was claiming to have the mistake about. You don't just get to write as the judge, if you believe there's been a mistake of fact, you can find the defendant not guilty. What you have to write is, if you believe the defendant formed a reasonable belief that the bath water was a normal temperature, then you will find that a mistake of fact existed and you will find the defendant not guilty. And so because they didn't specifically apply it to those facts in Baez versus State, that case got reversed. Now let's look at another case, Traylor versus State. James Mark Traylor was convicted of assault on a public servant, enhanced by 3 prior convictions, and was sentenced to 40 years in prison. The court held that the trial court did not err when they failed to submit a mistake of fact defense that amounted to that he didn't know that the police were actually police because they were in riot gear and not standard police uniforms. The mistake of fact instruction was not necessary, they said, citing another case. And you don't commit an error when basically the elements of the offense include the requirement to have that mental state. So in an assault public servant, you have to know that they're a public servant. And so the court said it was not an error to deny the specific charge of mistake of fact because the jury would have still had to believe that he knew they were police in order to convict him of the offense in general. And that is Mistake of Fact 8.02 of the Penal Code. Thanks for watching. Don't forget to like and subscribe, share our video, put suggestions if you have a video that you want us to do, put it in the comments. We'll see you next time.